seated. Good afternoon. We welcome all. We are now on the record in Re Allegiance Coal USA Limited, which is case number 23-10234. Ms. Topper, you can proceed.
Good afternoon, Your Honor. For the record, Paige Topper with Morris Nichols Arch and Tunnel on behalf of the debtors in these Chapter 11 cases. With me in the courtroom today are my colleagues Robert Denny, Matt Harvey, and Evan Thea Hammer. We also have in the courtroom Chris Walker. He is the Chief Financial Officer of the debtors. He is also, or will also be appointed, assuming that the interim DIP order gets entered today, he will be appointed as the Chief Restructuring Officer for each of the debtors. And finally, he's one of the declarants today for the DIP motion. We also have in the courtroom Matthew Hart. He's a Managing Director at CRS Capstone Partners, the debtor's financial advisor and investment banker in these cases. And then to my left, we have Mr. Lerner and Mr. Samus. They represent Collins Street, the debtor's prepetition note holder, as well as the proposed DIP lender. And we have finally Mr. Gaffey, who represents the committee here as well, Your Honor.
Okay.
So I first just want to start by thanking the court for accommodating us. We appreciate you moving up the hearing a day to have us heard. We are pleased to report that we are here today, hopefully on a largely uncontested basis, with a proposed DIP with the debtor's prepetition note holder, Collins Street. The negotiations between the debtors and the prepetition note holder since we were last before the court have certainly been extensive, but I think I can speak for both parties in saying that we're happy to propose today's DIP motion and that an agreement has been reached. What this means, Your Honor, is that the debtors now have some stability in these cases, again, assuming the order gets entered today. The debtors would not be facing litigation with Collins Street and can instead focus on operating their business and pursuing a transaction, either through a sale or some other refinancing as set forth in the milestones in the proposed DIP term sheet. And that is on an expedited process, Your Honor. The milestones provide for a 90-day process. Approval of the DIP facility today will provide the debtors with critical liquidity and should reassure the debtors' employees, vendors, and other creditors that the debtors will maintain sufficient liquidity to satisfy their operational needs going forward in these Chapter 11 cases. For today's hearing, Your Honor, the majority of the items have been resolved on the agenda with orders entered earlier this week. For the open items, I had proposed that we address the DIP motion first, which is item 9 on the agenda, and then follow that with Capstone's retention application. And then I have a few housekeeping matters to discuss at the end of today's hearing.
In the absence of any objection, you can proceed as you propose.
Thank you, Your Honor. So turning to the DIP motion, I would, as an initial housekeeping matter, like to admit into evidence the declarations that were filed in support of that motion. Mr. Walker and Mr. Hart, as I mentioned, are both present in the courtroom today and are available for cross-examination to the extent necessary.
Okay, so those two declarations, I believe, are at docket items 207 and 208.
That's
Is
correct.
there any objection to the admission into evidence of those declarations? Okay, seeing none, they will be admitted.
Thank you, Your Honor. As I noted at the outset, the debtors are seeking authority today to obtain DIP financing with their prepetition lender, Collins Street. Today, the debtors are seeking interim relief, and we have been in touch, in fact, with Chambers regarding a hearing for final relief, and that is penciled in the proposed order, Your Honor, for April 27th at 9:15 a.m. The DIP facility is for an aggregate principal amount of up to $10 million, comprising up to $5 million in new money advances, as well as up to $5 million for a roll-up of prepetition obligations. Through the interim order, Your Honor, the debtors are seeking authority to borrow $1.3 million, with the remaining principal amount to be borrowed in several draws after entry of the final order, as well as in accordance with the approved budget attached to the proposed order. The roll-up that I noted, Your Honor, is subject to entry of a final order. As detailed in Mr. Hart's declaration, Capstone contacted 26 potential parties, in addition to Collins Street, who Capstone believed would be the most likely candidates to provide DIP financing for the debtors. Ultimately, only two parties shared DIP term sheets proposing certain DIP financing. That was Collins Street as well as a third party. The third party elected not to proceed with the transaction at this time, leaving the DIP financing with Collins Street as the only option today. The debtors in Collins Street engaged in extensive good faith negotiations and exchanged multiple rounds of the DIP term sheet, the proposed budget, and the interim order. And the debtors believe that the proposed term sheet and the interim DIP order are the best available solution to the debtors' financing needs under the circumstances, and will provide them, as I noted, with the necessary liquidity to satisfy their operational needs going forward. I think, Your Honor, before we turn to the proposed order, which we did provide a red line shortly before the hearing, I might step away and see if anybody else wishes to be heard or if the court has any questions on the motion itself.
So I've reviewed the motion and the declarations in the order. I don't have my own questions, but obviously if anyone else would like the opportunity to be heard, I want to make sure they have that opportunity, even if it's Mr. Denny.
Hello, Your Honor. Very happy to be here, not fighting. The only reason I jumped up is I was on the last phone call as we were coming into the courtroom with Mr. Barrett. If you recall, Mr. Barrett and his firm represent Warrior Met, and they are the royalty, here he is. Hey, Kevin. They are the royalty, mineral rights royalty lessor for our Black Warrior mine. We've reached an agreement, so there have been a lot of discussions. There are 2 points that remain open, so I just wanted to jump up so that we don't have to go back and forth. There are 2 issues. In the DIP order, Mr. Barrett wants to make clear that there's not a DIP lien being granted on the lease. We think there's language in the order that addresses that by saying what's allowed and not allowed, but we and the DIP lenders have agreed, Mr. Lerner has agreed. After the hearing, he's going to talk to his client. Mr. Barrett's going to talk to his client. If it's acceptable, that's great. Otherwise, we're going to submit it with a footnote at the sentence, making clear that issue is going to be kicked to the final hearing.
Okay.
The second issue that Mr. Barrett raised is the priority of his adequate protection lien and whether that is above or below the carve-out that's being provided.
And does the current form of order say it's pari passu, or am I confusing that with something else?
We believe, and we've talked about it, it's above the adequate protection lien. Mr. Barrett is going to talk to his client to see if that's a problem. If it is, we'll come back to Your Honor if we can't resolve it some other way. But those are the 2 issues that remain open, but we all agreed to proceed, have Your Honor close the record, approve everything, and then we would submit the order once we have an understanding with Mr. Barrett.
Okay.
So I just wanted to make sure we covered that.
Okay. Mr. Lerner.
And
I'm sorry. Go ahead, Ms. Tupper. I'm sorry.
Page top of the record. I believe the Warrior Met liens, adequate protection liens, are pari passu to Collins Street's adequate protection liens.
So that's what I was thinking.
Yes. Yeah.
Okay. Thank you.
Good afternoon, Your Honor. Stephen Lerner, Squire Patton Boggs, on behalf of Collins Street. Agree with all the presentation that Ms. Topper made. We are also very pleased to be here in a constructive financing and avoiding any unnecessary litigation. I don't want to further complicate things, but we've agreed for Collins Street that our liens, all of our liens, are subject to the carve-out. Mr. Barrett is talking to his client to see if that's acceptable, but while we have not raised the issue of seeking to elevate our liens ahead of the carve-out, if the outcome here is that somehow this is contested and the court provides that Mr. Barrett's client is ahead of the carve-out, we're going to need to be there. So I don't want to go there, but I just want to
hear you. Look, let's proceed on the assumption that nothing's final until everything's final.
That's
but that as of now, there are 2 issues that the parties will try to work out. If they can't be resolved, we'll deal with them. It looks like no one's asking me to enter an order until you've got appropriate language that marks those issues as open. Am I understanding that correctly?
That's correct, Your Honor.
Okay. So
that's perfect.
To the extent what you're asking me to do is something that you all agree to, that's really what I do best. So I think we're good there.
Great. Thank you, Your Honor.
Good afternoon, Your Honor. Richard Shepard for the United States Trustee. On the topic of nothing's final until it's final, I just wanted to indicate that there were informal comments that our office made with respect to the order. All of those comments, I believe, have been resolved in this interim order. and that to the extent that there's a final hearing, we reserve any and all rights to review that order at the time when it's submitted. Thank you.
Thank you, Mr. Shepard-Carter.
Good afternoon, Your Honor. Dave Gaffney, Whiteford, Taylor, and Preston, proposed counsel for the committee. We've been kept apprised of the progress of the DIP discussions. We've provided our initial issues to the interim order to the lender and debtors and reached agreement on a number of points. Those points have been incorporated into the revised interim order. I think there's many issues that we intend to discuss over the coming weeks, but we've had productive discussions with both the lenders and the debtors, and we expect those to continue as time goes on. So with that, subject to resolution of the issues raised by Mr. Denny today, we have no issue with the entry of the interim order as drafted. Thank you.
Terrific. Thank you. Okay. Yes, Mr. Barrett.
Thank you, Your Honor. I just want to make one clarification or point. Obviously, we're talking about the amendment order, and we're obviously reserving our rights relative to the final.
Okay. So the only thing that's in front of me right now is the interim order. Everyone's rights with respect to everything are preserved as to the final order. That goes out on an ordinary notice, and there's an objection deadline. And if I get an objection, we'll have a hearing and we'll sort it out. With respect to the interim order, what I understand the state of play being is that there's an agreement in principle with two sort of bracketed points, and the parties are going to talk, and they'll either resolve those points or they will leave them bracketed to be addressed at the final hearing. No, I'm sorry, Mr. Denny. I'm sorry. So if they're not resolved consensually, you'll present me dueling forms of order, and I'll have to pick.
Or I just mentioned to Ms. Topper, or we may just ask for a quick Zoom hearing tomorrow because we know we need the order entered. Collins Street's prepared to fund. So
okay. All right. So with respect to the two remaining issues, you'll either work it out or
come back to Your Honor.
Come back, and then I'll do my job.
Yes.
Okay. Very well. Okay, Ms. Tupper, sorry to cut you off.
It's no problem at all, Your Honor. So turning now to the proposed interim DIP order, as you've seen, we did receive several informal comments from several parties, including the Office of the United States Trustee, the committee, Warrior Met, Mr. Barrett's client. We also received comments from Crum and Forster, they're an insurance company, for the debtor's D&O policy, providing for some reservation of rights language at the end of the proposed order. And then we received a comment previously from Klein Mining Corporation's counsel, and that comment was really just to make sure that any adequate protection provided to Warrior Met was likewise provided to them. So I'm happy to answer any questions you have with respect to the order, Your Honor. I know we gave you a red line fairly late, so if you would like me to walk through, I can do that too.
So I've been through the form of order and the red line, and nothing jumped out at me that requires me to detain everyone. So I'm obviously interested in seeing what comes in on final resolution if you get to one, but look, subject to the parties working out these last issues, I'm satisfied that the debtor has met its burden of showing that it requires an extension of credit, that it has shopped and gotten the best deal that it can get, that it couldn't obtain credit on an unsecured basis, et cetera, and therefore that the entry of an order authorizing the debtor to enter into the DIP loan is appropriate and subject to the final points about the language, making sure everyone's rights are appropriately respected. I'm more than prepared to enter that order.
Okay. Thank you, Your Honor. And so we will be in touch, hopefully, with a consensual proposed order. Okay. That brings us to the next item on today's agenda, Your Honor, and that's Capstone's retention application. There was one limited objection filed by the official committee of unsecured creditors, but I am pleased to also report that that objection has been resolved. The parties are working on providing a revised proposed order and plan to submit that under certification of counsel. But I will cede the lectern over to counsel for the committee to give a high-level overview of the resolution that was reached there.
Okay.
Thank you.
Thank you.
Good afternoon, Your Honor. Dave Gaffney of Whiteford, Taylor, and Preston, proposed counsel for the committee. We have no issue with Capstone's qualifications or their engagement as the dual financial advisor and investment banker. Our sole issue related to the transaction fee that they were proposing to receive upon any sale or financing transaction. We laid out our concerns in our objection, which generally are the lack of a minimum transaction value to trigger a $500,000 fee, the amount of minimum fees potentially paid on lower value transactions like DIP financing, and then the possibility of multiple transaction fees that could be disproportionate in the aggregate to the net value received. I'm happy to report we've reached an agreement with Capstone. With the court's permission, I'd like to read the agreement into the record, and then I believe, as Ms. Topper noted, we'll submit a revised order.
Okay, you can proceed.
Thank you, Your Honor. So the committee and Capstone have agreed as follows. For a DIP financing transaction fee, the fee will be the greater of 1.75% or $250,000 for DIP transactions. That's half the prior minimum fee for DIP transactions. If there are multiple transactions, the minimum transaction fee will be $500,000 if the assets are sold together, $375,000 per transaction if the assets are sold separately, with a maximum of 2 minimum transaction fees for a total of $750,000. If there's a third or subsequent sale, then Capstone would receive its 1.75%. For the minimum transaction value, if the joint assets sell for less than $10 million, the otherwise applicable minimum fee would be reduced by 50%. And if there is a credit bid sale to Collins, Capstone will receive the greater of 1.75% or 50% of the otherwise applicable minimum fee. And the currently hourly fee arrangement, Capstone is currently proposed to be paid hourly as they are in the financial advisor fees. That will be converted to a $100,000 a month fee, with 50% of those fees credited against the transaction fees after 3 months. So unless the court has any questions with these changes, we would support Capstone's employment application and see the podium back to the debtors if they have anything to add.
Okay, no questions from me.
Thank you, Your Honor.
Thank you. Stop it.
That's acceptable, yeah. That was all accurate. Debtors agree with what Mr. Gaffey just represented.
Okay, so I take it a revised form of order will be submitted under certification or just upload? I mean, if given the representation in court, if it's just uploaded, I'm fine with that unless anyone else would prefer the formality of it being submitted under certification. Okay, seeing none, I'm happy to have you just upload an order, so providing, and we will get that entered.
Okay, thank you, Your Honor. That leaves me, Your Honor, just with 2 housekeeping items for today. The first is I wanted to see if we could get a hearing date for the bid procedures motion that will be filed. Because of the milestones in the DIP term sheet, we're looking for a hearing date on May 2nd.
Hold on a second. I think we may be able to do that. Let me just pull up my calendar. I apologize. So this is a hearing on approval of bid procedures. This is obviously when would you contemplate, without holding you to it, that the motion would be filed?
So the motion has to be filed, Your Honor, by this upcoming Tuesday of next week.
Tuesday of the 18th.
Well, let me say the motion has to be filed within 5 days of entry of the interim DIP order.
Okay, understood.
So possibly Wednesday of next week.
Oh, okay. And so, again, let me ask this question. So that obviously entails shortening notice. Oh, or is that a 2-week?
That would be 21 days out. May 2nd from Tuesday would be 21 days, I believe.
No,
Unless my math is-
I think it's 14.
Oh, then I'm sorry. Let me request the right date. I apologize, Your Honor. May 9th.
Okay. So I believe that May 10th is open. May 9th, there may or may not be availability. Is there a material difference between the 9th and the 10th for approval of bid procedures?
No, Your Honor.
Okay. Well, why don't we...
It is a milestone, but I am,
I see.
relying on Mr. Lerner saying it's not an issue.
Okay. Okay. So why don't? Oh, actually, I lied. May 10th doesn't work. All right. We'll find a way to make it work on the 2nd. Why don't we set it for 3:30 on May 9th?
On May 9th, okay.
Ms. Barksdale, have I done something terrible? Let me give, this is without prejudice, Ms. Barksdale's right to
That's
tell me
fine.
that I've lost my mind. Well, so we have an omnibus at 1. I don't see that going past 3:30. So I think setting this at 3:30 is okay. All right, so let's do this at 3:30
Thank you, Your Honor.
on Tuesday, May 9th.
Thank you. And then the final housekeeping matter, Your Honor, is we noticed that the interim compensation procedures order, in the compensation procedures that are attached to that order, and that order was entered earlier this week, the notice provision for the notice parties lists Collins Street's former counsel, so we would just like to upload a new order and have that entered.
If you upload an amended form of order in the absence of any objection, I'm happy to enter an amended order that simply corrects or updates or corrects an error or what have you. So that's fine.
We will do that, Your Honor. Thank you.
Okay. Is there any other way in which the court can be helpful?
That is it, Your Honor. Thank you for your time.
Okay, so just so I've got this right, with respect to the matter we just talked about, you're going to upload an order, the compensation procedures. Yes. With respect to the retention of capstone, you're going to upload an order. We're going to enter that. With respect to the DIP loan, you'll either upload an order or you won't. I guess with respect to the DIP loan, would you, if you resolve it, would that come under certification?
We can do it under certification of counsel.
All right, I think that would just, given under the circumstances, would be appropriate. So why don't, if that's resolved, submit that under certification, we'll then get it entered. And if you fail to resolve the issues, just reach out to Chambers and we'll try to hear folks tomorrow.
Thank you, Your Honor.
From the debtor's perspective, is there anything else that the court can do this afternoon?
Nothing from the debtor's perspective, Your Honor.
Okay. Is there any other party in interest that would like the opportunity to be heard on any matter while we were here? Okay. Seeing none, it's delightful to have an easy hearing in this case. So thanks to all of the professionals for their good and hard work. And with that, we're adjourned. Thank you.